Okay, good morning. Let's go on the record. Today's date is August the 11th of 2020. It is currently 10 a.m. We're in room 310 of the Governor Office Building. Before I start this hearing, I'd like to go over the policies for this hearing as they relate to the COVID-19 pandemic. I'm going to ask that everybody who enters the courtroom enter through the door near the Madison Street, and that if you exit via the door by the bench. By doing that kind of one-way thing, it prevents people from bumping into each other in narrow corridors. I'm going to ask that we social distance as much as possible. That doesn't appear to be a problem in the courtroom right now. I'm going to ask that everybody wears a mask. If somebody comes in and is not wearing a mask, I'm going to ask them to leave and step into the hall and wait to the end to make their comments. I'm going to ask that as much as possible, if you are seated at a seat with a microphone, that you make your comments from the seat that you're sitting at. If you elect to use the podium or need to use the podium, when you approach the podium, there is a thing of hand sanitizer on the podium. I'm going to ask that you sanitize your hands before you touch the microphone. Now, the Commission has set aside this time today for a rulemaking comment hearing for oral comments in the file captioned as in the matter of the proposed amendment to 4 CSR 240-20.060 filing requirements for electric utility cogeneration. And that is file number EX-2020-0006. And the subject of this hearing involves... Okay, I'm getting some background noise. I'm going to ask that if you're not commenting, that you keep your mic muted. I'm also going to point out that because this hearing is being done both via WebEx and over the web, there's no video that's related to WebEx. You can only participate via audio over WebEx. So if you've got the video on in the background, which is going to be off time by several seconds as it's streaming on the PSC website, I'm going to ask that you turn the volume down on that so that we don't pick that up as well. So please mute if you're not speaking and keep the volume down on the website stream. To continue on, the subject of this is the rescission of 20 CSR 4240-3.155. And that would be requirements for electricity. Okay, I'm picking up some feedback from somebody. Is there anybody who doesn't have their microphone muted? Okay, that seems to be somewhat better. And that's the rescission of the requirements for electric utility cogeneration, tariff filings. And the amendments for which comments are being received today are for 20 CSR 4240-20.060, cogeneration and small power production, and 20 CSR 4240-20.065, net metering. Again, I'll probably say several times during this thing, if you are not speaking, please mute your microphone. At this, my name is John Clark. I'm the regulatory law judge conducting this rulemaking hearing. At this time, I'd like to have the attorneys enter their appearance for the record. I will go down the list of parties that have submitted comments, starting with staff.
Karen Brett, staff of the Missouri Public Service Commission, P.O. Box 360, Jefferson City, 65102.
Thank you, Ms. Brett. For the Office of the Public Counsel.
Good morning, Judge. Caleb Hall, appearing on behalf of the Office of Public Counsel, 200 Madison Street, Suite 650, Jefferson City, Missouri, 65201.
Thank you, Mr. Hall. Is there anybody present from Ameren?
Yes, Your Honor. This is Paula Johnson, Senior Corporate Counsel for Union Electric Company, DBA, Ameren, Missouri. Business address 1901 Choteau Avenue, St. Louis, Missouri, 63103.
Thank you, Ms. Johnson. Is there anybody here for the Empire District Electric Company? I hear nobody. Is there anybody here for Evergy? Mr. Fisher, I can actually see your video that you're trying to talk. I believe you're muted. Mr. Fisher, can you hear me?
I can, but I can't seem to unmute. Go ahead.
I unmuted you, sir. If you'll go ahead. Please enter your appearance for the record.
Yes, appearing on behalf of Evergy Metro Inc., doing business as Evergy Missouri Metro, and also Evergy Missouri West, doing business as Evergy Missouri West. My name is Jim Fisher, and I'm with the law firm of Fisher and Doherty, 101 Madison Street, Suite 400, Jefferson City, Missouri, 65101.
Thank you, Mr. Fisher. Renew Missouri.
Thank you, Judge. Tim Opitz on behalf of Renew Missouri. My address is 409 Vandiver Drive, Building 5, Suite 205, Columbia, Missouri, 65202.
Thank you, Mr. Opitz. Is there anybody here from the Midwest Cogeneration Association? They filed written comments. I hear no one. Is there anybody present from the Missouri Solar Energy Industries Association? They also filed written comments. I hear no one. Is there any counsel I've not called upon? Okay, I hear no one. I will point out that this is a rulemaking hearing. This is not a contested case, so there's no cross-examination from the parties. The commission may, however, have questions for those who are making comments. If you provide a comment, please sure to state your name and your position. I guess I'm going to start with those who are present. I'm going to start running backwards from the electrical corporations who submitted comments through Renew Missouri to OPC and finally ending with staff. So Ms. Johnson with Ameren, did you have any oral comments that you wish to make?
I do, Your Honor. Thank you very much. The first thing I would like to state is that as the parties are aware, the FERC, the Federal Energy Regulatory Commission, on July 16th, issued rules regarding...
Hold on just a second, Ms. Johnson.
Certainly.
I'm sorry, can she start again and maybe turn her volume up?
Ms. Johnson, the court reporter is asking if you would start again, and can you maybe speak just a little bit louder or turn your volume up?
Okay. Is this a better volume?
We will do the best we can.
Okay. Sorry, I will try to make sure I speak slowly and clearly. My apologies. I think it is important to note that FERC on July 16th issued a rulemaking order that very significantly the PURPA rules, Public Utility Regulatory Act rules, that have been largely unchanged since the 70s and 80s, with the exception of some revision act. Now, the reason this is important, and I bring this to the Commission's attention, is there are a lot of competing timelines in the Commission's proceeding that when you sit down and draw a line through them, make it very clear that we've had no real opportunity to look at these FERC rules over the course of developing these Commission rules. Example, in file number EW 2018-0078 and EW 2017-0245, the latter one in particular, I believe that was the last time, that was the emerging issues docket. I believe that's the last time any comments were made regarding these specific rules in the emerging issues docket. And I believe it was also approximately the last time any comments were made in the cogeneration rulemaking docket. Now, it was a month after that, or nearly a month after that, on September 6, 2019, that the Renew Missouri rulemaking docket, EX-2020-0006, was closed. Now, it wasn't until September 19th, 2019, that FERC actually issued its Notice of Proposed Rulemaking, and in docket number RM 19-15. So that was the first real instance where we had the good substance of what FERC was seeing in its draft rules. And none of those other dockets had been able to appropriately consider those. Now, in the Commission's file number EX-2020-0006, that is when the Commission sent its proposed rule for publication in the Missouri Register. And they were published finally on July 1st, 2020. On July 16th, 2020 is when FERC issued its rulemaking order. So when you actually look at the timeline, while we knew there was going to be an activity at FERC, I mean, Ameren Missouri pointed that out in its August 2018 comments, we didn't know the substance of what FERC was going to do until most of the comments were already completed in the other proceedings, and we didn't have the rulemaking until after these proposed rules were published. Now, the net metering rules, we think those are fine to go forward. We don't have any issue with those going on because they're somewhat impacted, but not significantly impacted by what's going on with the cogeneration and small power production rules. But this is really the first real opportunity we have to address the substance of the FERC rule. So we would like to suggest that we take that portion of the rulemaking back to a workshop so we can more sensitively consider what it is that FERC has given us guidance on in these rules. We understand that, we're 4 days out from the time limit for parties to ask for reconsideration of the FERC rule, but even if it gets tied up, we still have a lot of very useful information from FERC that could help inform and better create the rule, an effective rule for the state of Missouri. And we may as well accept that guidance because it is very much representing
Sorry, it's very much what?
I'm sorry, Ms. Johnson, can you back up to it's very much? Ms. Johnson?
Oh, it's, can you hear me?
Yes, I can now.
Okay, my apologies. I think it's very important that we go back and try to consider the guidance that FERC is giving us, because even if it's tied up in reconsideration or rehearing, it still very much shows the mindset of FERC and very valuable guidance. And some of those, if the rule does become permanent, are going to be things we really need to consider. First, I want to talk about the creation of the legally enforceable obligation. And to quote the fact sheet, which is summarizing the order that FERC set out with its order, the new rules regarding legally enforceable obligations require, and this is a quote from that rule, or from the fact sheet, require states to establish objective and reasonable criteria to determine a QF's commercial viability and financial commitment to construction before a QF is entitled to a contract or legally enforceable obligation. Now, that's something that's not considered in the current rule. And if the FERC rule becomes permanent, then we have a state requirement and we have an opportunity to go ahead and work on building those criteria in now rather than having to redo the rule again after, after it's published. If the FERC rule becomes final, then we just have to pull one of these rules back and go through this process all over again. Now, Even if it is tied up in litigation, FERC does leave the criteria for the creation of a legally enforceable obligation to the states. And we have insights now into what some good criteria for that creation might be. So even if the FERC rule doesn't go into effect, it still is a good idea to come back and look at putting that definition in our regulations, which I can assure you, based on my prior legal experience, can help you avoid years' worth of litigation down the road. So even if the FERC rule does not go forward, this is still a good idea to try to address now, and we have some good objective criteria to look into crafting a Missouri rule on that topic. The FERC rule also proposes a lot of new flexibility and methodologies and how to establish energy rates in QF power sales contracts. I mean, we're looking at when there's fixed pricing, we can still look at forward pricing curves. And, when we're looking at as available energy, we can look at competitive solicitations, and we can do formulas that are based on heat rates. All of this is stuff we have not had the opportunity to fully workshop, and I think it wouldn't hurt anything to pull it back and begin to look at this and see if we can work on some of this new guidance and codify these guidelines now rather than making these determinations through litigation in the future. I also wanted to quickly address comments made by a couple of discrete comments that were made by others in this proceeding. In some of the filed comments in this docket, there was a suggestion that the standard offer contracts should contemplate sales up to 20 megawatts. That is another maximum that is based on the on the currently effective PURPA rule. If the new PURPA rule goes into effect, utilities will have the opportunity to apply to get their purchase obligation limits down to 5 megawatts. And currently Ameren, Missouri has applied for and obtained the 20 megawatt limit. We would also go in and apply for the 5 megawatt limit. And that is something that we want to see what happens. If we do accept like the suggestion of the 20 megawatt limit, that is another rule we may have to go back and revisit later if the PURPA rule becomes final and effective. I also wanted to state we got a preview of, we're very grateful to staff for sending us a preview of what they have, what comments they are going to offer. And I do want to very much thank them for clarifying how they envision the process regarding standard offer contracts. That was very, very helpful and has provided us some peace. I'll let them speak to that in more detail, obviously, but I did want to thank them for sharing those comments, and that we're very grateful and appreciative of the thought and consideration they've put into that. So I guess basically I just want to summarize. We think it's very, very important to consider the FERC rulemaking because it could have and very much will have, even if it's just in guidance in future litigation, it will impact how the parties are approaching these PURPA details in our execution of contracts and in our standard purchases. So we highly recommend that portion of the rulemaking be held back and explored through continued workshops so that we can actually have an opportunity to address the guidance, the substantive guidance from FERC that we have not had a real opportunity to address previously in this matter. And that concludes the remarks I had prepared that I wanted to address, and I'm happy to answer any questions.
Thank you, Ms. Johnson. Any questions from the Commission? Okay, I don't hear anybody. I've got one kind of brief question. It appears that a lot of the parties that filed comments indicated that they felt that this rule, at least in regards to the cogeneration, was a step in the right direction, but maybe did not go far enough. Given that those were some of the comments received, and taking in mind what you said about potential litigation, what do you see as the potential harm of the Commission's rule as it stands as an intermediary step, given that we could be years away from a FERC rule actually taking effect?
I think the biggest harm is, the opportunity for protracted litigation in the Commission. I will, if I may relay some anecdotal evidence for this. I used to work in the state of Iowa for Alliant Energy, and if you look at the Iowa Utilities Board dockets, there's a series of cases that lasted for several years regarding some wind farms that were wanting to hold Alliant to the purchase obligations. And Iowa at that point had not defined legally enforceable obligation. It did not have a lot of criteria in place for how you determine avoided costs. And what we ended up doing was we had 5 to 6 years worth of litigation in 4 connected cases. And it takes up a lot of time, it takes resources, and they're all things that could have been avoidable had issues such as legal enforceable obligation been defined from the outset, and had standards for how to calculate avoided costs been defined from the outset. So do I think we have things a step in the right direction? I think we do. But we have an opportunity now with FERC guidance on a lot of these issues and the benefit of a lot of different perspectives that they had to weigh to really help us out. Because when you think about it, right now, part of the calculation of avoided cost or the determination of legal enforceable obligation, ultimately, when we are making these purchases, our customers pay the price for those purchases. And if we know for sure we can do things like look at a forward pricing curve, then we feel like we're protecting our customers better also. And if we, rather than locking in at a solid rate for 20 years, if we know we can go out and if someone wants to give us as available energy, if we know we can go out for a solicitation and use that as evidence of what an avoided cost should be, then we know that at the outset, and we are ending up litigating, well, sure, you could use that competitive solicitation, but we could also look at how you're modeling your energy costs and use that. But we're going to adjust the rates in that to make the price even higher. So those are the 2 basic issues I see. One, we could end up in protracted litigation, and I've experienced that before. And well, it's job security. It's not my happy place. And number 2, the costs that if we can manage those costs at the outset, we keep costs down for our customers. So those are the 2 big vulnerabilities I see with going with the stopgap measure when we have this guidance available to work in now.
Thank you, Ms. Johnson. Any oral comments from Evergy?
Just briefly, Judge, Evergy filed joint comment. Oh, goodness. I just fell off a chair. Evergy just... I'm all right. Yes, thank you. I don't know. I have a stool here that just collapsed. Evergy filed joint comments with Ameren as well as Liberty. We had raised some technical issues there. I don't think I really need to go over those too much. I think I would join, though, in Paula Johnson's comments about the advisability of maybe having another workshop to go over the FERC order in some detail. One of the very fundamental aspects of this is calculating avoided costs, and it's my understanding that those calculations are still somewhat up in the air and fluid, and it might be worth our while to spend some time going over those and trying to make sure that we're together with where FERC is headed. So with that, that's really all I would say at this point. And I would ask you to look at our technical comments as well. Thank you.
Thank you, Mr. Fisher. Any questions from the commission? I hear none, and I have none. Moving on, any oral comments from Renew Missouri?
Yes, thank you, Judge. First, I want to thank the Commission for convening this rulemaking and proceeding ahead with it, despite the recent FERC Order 872. Renew Missouri, we offered pre-filed written comments on the 31st, and I encourage the Commission to adopt those edits. As an initial matter and to respond in part to the comments from counsel for the investor-owned utilities, I want to say that FERC Order 872 is not yet final. The rules that will stem from that will become effective after 150 days of being published in the Federal Register. Moving forward with our current rules would be consistent with the overarching message of Order 872, which continues to give this Missouri Commission the ability to grant independent power producers non-discriminatory access to the market, create transparency to avoided cost data, and to create the ability to enter into long-term fixed contracts with utilities. Before I get into my prepared remarks, I want to respond to two items. The first being related to the 5 megawatt limitation on the standard offer contracts. Renew Missouri had proposed a standard offer contract up to 20 megawatts. We still believe that's appropriate. First, because that is the current limit. And second, because Order 872 only changes that limit for small power producers, which are generally renewable energy production facilities. The 20 megawatt limit still remains at 20 megawatts for cogeneration facilities, which I believe one other pre-filed commenter pointed out, and we pointed out in our rules, our comments as well. So in the event that a cogeneration facility wants to come to Missouri in an investor-owned utilities territory, it would be important and administratively efficient for that 20 megawatt limit to remain. The second thing was related to not moving forward with the cogeneration rules because of a possibility for protracted litigation. And my response is that the Commission, Missouri Commission, still remains its authority to establish timelines on which cases proceed. One extreme example that I was a participant in was the Greenwood Solar CCN case a few years ago, where the procedural schedule from direct testimony filed to the hearing being conducted was, I believe, less than 1 month. So these, the idea that protracted litigation would run out of control, that's something entirely within the purview of the Commission. So now to my prepared remarks. Again, I want to reiterate that adopting Renew Missouri's proposed edits to the rule maintain this Commission's oversight regarding avoided costs, contract terms, contract lengths, and safety standards, rather than deferring them to a not yet effective FERC federal order. This has a benefit of allowing the regulators with the most direct contact with our utilities and with our state to have the most input. In my comments, I want to highlight some of these technical aspects of our proposed rules, as well as some of the policy reasons that supporting these rules makes sense for Missouri. First, PURPA requires non-discriminatory access to encourage cogeneration and small power production. This means that generally utilities have an obligation to purchase power from qualified facilities, being those small power production facilities or cogeneration facilities, at their avoided cost. This is the only real competitive pressure on vertically integrated utilities, whether or not they are inside an RTO market. And even within RTO markets, as our investor-owned utilities are, qualified facilities of all sizes, many of which could interconnect on a utilities distribution system, face barriers to entering that transmission market. This is particularly true for systems smaller than 20 megawatts. As the Commission is aware, PURPA covers facilities up to 80 megawatts, but recent or not so recent decisions have said that units smaller than 20 megawatts are presumed to not have non-discriminatory access to the market. As we point out in our filed comments, the proposed FERC rules, even the new rules, implicitly recognize that systems of 5 megawatt for the small power production facility and 20 megawatt for cogeneration facilities do not have non-discriminatory access to the markets. And again, as I pointed out in our comments, the dissenting opinion called this a gutting of the current rules. But that is still 5 times greater than the Missouri's proposed rule, which is, to be clear, an improvement from what we have, 5 times greater than what we are proposing to move to. One way that Renew Missouri proposes to increase our non-discriminatory access to these QFs is to require meaningful standard offer contracts. The availability of standard rates brings advantages by reducing transaction costs and reduces the need for every qualifying facility and the utilities involved to negotiate for systems that would bring benefits to the grid, to customers, to purchase power at the avoided cost, and to the environment in the case of renewable small power producers, and in the case of some cogeneration through decreased emissions on site. By increasing the sizes of standard offer contracts in its Missouri regulations, this commission would take steps to significantly encourage the development of these qualified facilities as the PURPA statute requires. What we have proposed is expanding the standard offer contracts in the commission's rule to include levels of 2.5 megawatts, 5 megawatts, and up to 20 megawatts. The reason we propose these is because the 20 megawatts is the outside limit that's currently in place. The 2.5 and the 5 megawatts were previously under consideration by the Commission when it asked the IOUs to examine whether they would be able to put these sizes on their distribution network. The utilities' responses were varied, but Renew discussed 3 considerations that they raised in their comments. First, it's worth noting that KCPL, now Evergy, pointed out that it would be able to accommodate varying sizes of the customer system, including 1 megawatt, 2.5 megawatt, and 5 megawatt systems as a part of a standard offer contract through site-specific analysis and any resulting upgrades needed for the distribution system. KCPL noted that it could do this because the regulations currently and as proposed in the Commission's rule require the qualified facility to pay for interconnection costs. Empire's comments point out that safety and reliability should be a primary concern when thinking about adding QFs. Renew Missouri agrees that safety and reliability are important, but those should not be the reasons to not offer standard offer contracts that have avoided costs and contract terms within them. The standard offer contracts can incorporate safety and reliability metrics that should be met. And furthermore, the proposed rule already includes provisions that say each electric utility will develop technical and performance standards and interconnection test specifications to its distribution system to be included in its standard contract template. Technical and performance standards will include provisions related to metering, protection of equipment, and disconnection switches. In Renew Missouri's view, it's reasonable to require qualifying facilities to adhere to safety and performance standards. And the best way to accomplish meeting those standards while providing transparency to potential QF developers is to include these requirements in the utility standard offer contracts to be filed with the Commission. The last utility, Ameren, Missouri, pointed out its view that different standard offer contracts might not actually encourage qualified facility development because the distribution system impacts would be facility specific, and QF participation rates are not a function of only the capacity of the SOC, meaning, the 5 megawatt or the 2.5 or the 1 megawatt or the 20 megawatt limits, but they're also very dependent on the price and the term of the standard offer contract. We agree that those are considerations that will encourage development of QFs. But we disagree with Ameren that means we shouldn't offer QFs up to that size. Our response is we can address those issues by including contract term and the avoided cost in the standard offer contracts. On avoided cost methodology and contract length, I would say the Commission's proposed rules are an improvement on avoided cost transparency, but an opportunity for comments by the parties would improve the record for the Commission to make its decisions. I will say it was pointed out that there may be new methods available for the utility and the Commission to determine avoided costs. I think that the Commission's proposed rule already accommodates the availability of utilities to put forward those methods, assuming that the FERC rule becomes effective. And that would be in section D, sub 4, where it says the electric utility may propose any other method that can be demonstrated to reflect avoided cost. So in my mind, that's another reason why there's no need for delay to wait on the FERC rules. The utilities could propose that. This Commission, in its proposed rules, has a variety of, I believe there's 4, and that 4th one being the one where the utility can propose its own method, ways of determining the avoided cost to be included in the standard offer contracts. The Commission has experience examining avoided cost and determining what is appropriate for each utility. Prominent examples include MIA cases in Missouri. In Evergy and Ameren's recent Cycle 3 filings, avoided costs were a prominent issue. In Ameren, the parties reached an agreement that talked about forecast avoided cost. In Evergy, it was the primary determination that the Commission had to make, and it did so. Encouraging both MIA and qualified facility development relies on avoided cost, and just as our investor-owned utilities say they will not be able to pursue energy efficiency without appropriate avoided cost compensation, QF developers can't begin projects without knowing what the avoided cost compensation is that they will receive or the term of it. And that's part of the importance of standard offer contracts of a size that will allow them to achieve certain economies of scale. Prior MIA cases also provide some indication about the necessity and certainty regarding the length of contract in conjunction with long-term IRP planning. In prior cycles of MIA, the utilities have argued that the avoided cost rates used in developing the plan should continue to be static based on the IRP avoided cost at the time that they began the program. Their rationale was that this static cost, which the current FERC rules and the proposed Commission rules would allow, is that they need certainty to begin moving forward with these projects. So again, the Commission has experience examining avoided costs, and it has experience examining how long those avoided costs should be in place, I guess as an analog for contract length. The assumption that long-term contracts at Commission-determined prices will be potentially above the market is unfounded. Again, PURPA requires the purchase to be made at the avoided cost rate, which could result in savings for the customers. allowing longer-term contracts and larger qualified facilities than 1 megawatt, as Renew Missouri proposes in its rule, enables these QF developers the certainty and cost recovery to move forward, just like the utilities need certainty and cost recovery to move forward. No large-scale utility investment gets made by any party without certainty regarding projected revenues. For our IOUs, they recover that through rate cases, and those rates established by the commission, which necessarily subjects ratepayers to price risk in exchange for certainty of generation supply. In the case of investor-owned utilities, when they construct a project, the ratepayer also, however, carries the risk of construction cost overruns, operation and maintenance expenses, and with non-renewable resources, the price volatility. With an IPP, and in the case of qualified facilities, the financiers bear all the risk of developing the qualified facility. The rate that is established by the commission and the rate that they begin to take under at the implementation of the legally enforceable obligation is set. Furthermore, again, under the rules at sections 4 and 11, these standard offer contract rates would be approved by the Missouri Commission. And this is another opportunity for the Commission to exercise its obligation and its authority to ensure that Missourians are paying just and reasonable rates for electric service. However, in the standard offer contract, it would be through an independent power producer rather than through the utility building it itself. Counsel for Ameren, Missouri stated that the LEO definition has changed in the proposed rule and indicated that it was important consideration. Renew Missouri has proposed a definition and a process for when an LEO is established in our proposed rules. We agree that that is an important consideration in the rule because that's when the developer is able to fully be aware of the prices and the term of the contract that it will have in order to develop its project. So those are some of the technical modifications that Renew Missouri proposes. One policy reason, as I mentioned, I talk about some of these policy reasons, is that fully implementing PURPA through Renew Missouri's proposed revisions can help make Missouri competitive for corporate investment. In addition to allowing customers to benefit from the economic and renewable generation purchased at avoided cost, implementing our changes will create other benefits to Missouri. In several recent CCN cases where our utilities have proposed renewable generation, Renew Missouri offers testimony that a growing number of customers want more access to renewable energy resources to meet their own sustainability metrics. This is evidenced by dozens of major companies that have signed on to support the corporate renewable energy buyers principles and governmental bodies such as the cities of St. Louis and Kansas City establishing their own clean energy goals. It's our view that just as we support it when the utility pursues this renewable generation, and it will help satisfy corporate buyers' desire for renewable energy, the ability of independent power producers to sell their renewable energy to the utility will attract and help corporate energy buyers meet their metrics. Furthermore, in our comments, I want to point out we attached the Corporate Clean Energy Procurement Index for 2020. This was a report created to guide commercial and industrial renewable energy electric usage across the United States. The index ranks all 50 states based upon the ease with which companies can procure renewable energy based on indicators tracking policy mechanisms and current deployment levels. Basically, the report finds that Renew Missouri, or Missouri, is in the bottom half, ranking 29th at availability of interconnection to distributed generation systems to the grid. for improving our commission's cogeneration rules to better align with PURPA as Renew Missouri proposes should make Missouri more competitive for corporate energy procurement and increasingly for site location. The ability to attract companies within that report focuses largely on retail customers, big box stores. But Missouri has seen recent cases where the ability to attract industrial customers can be advanced by renewable energy. For example, the Nucor steel mill in Sedalia, Missouri, the commission allowed Evergy to obtain the power needed to serve Nucor by entering a purchase power agreement for the delivery of wind power. I know this was a significant consideration in allowing that project to move forward, at least by some stakeholders in that docket. In that case, importantly, I think it's worth highlighting the economic benefits again, that upon completion, that project would encompass more than $250 million of private investment and create 250 new employment opportunities with an average salary of $65,000. Increasing renewable access results in real investments and jobs in Missouri with economic opportunity. This is always important in Missouri, but it's increasingly more so during the current economic downturn caused by COVID-19. Another policy reason Renew Missouri proposes modifications to the rule is that fully implementing PURPA's mandate to encourage small power production and cogeneration will lead to direct economic benefits. Failing to implement PURPA so far has caused Missouri to lag behind other states in developing renewable energy and realizing the attendant economic benefits. We have filed comments in the previous workshop and in our own petition for rulemaking last summer, comparing Missouri to the example of North Carolina. North Carolina had robust PURPA implementation rules, which catapulted that state to second in the nation in installed utility-scale solar, owned by independent power producers, which was responsible for billions with a B of dollars in private sector energy investment in that state. While North Carolina has a comparable solar resource and a relatively comparable population profile to Missouri, the state had approximately 25 times the amount of installed solar. In North Carolina, those companies caused $7.75 billion in investment and employed over 6,500 people. Missouri's investment so far is just over $500 million, and there's been about 2,819 employees. As the commission can see from the comments filed by MOSIA, the current economic downturn has hit solar installers, and they are concerned about prospects moving forward, at least based on my reading of their comments filed. As Missouri continues to suffer from shrinking economic prospects, these rule changes proposed by Renew are a tangible and significant way the commission can help jumpstart our recovery while providing energy to customers at the avoided cost. Lastly, I just want to again thank the commission for moving forward with this docket. I would encourage the commission to adopt our changes included in our pre-filed comments in order to help get Missouri on the right track for encouraging qualified facilities as FERC requires, and the types of valuable market investment that will make Missouri's grid more decentralized, efficient, diverse, and resilient. Putting these changes forward will result in a more favorable economic market and attract businesses to our state, and I encourage the commission to do so. That's all the comments I have. Thank you.
Thank you, Mr. Opitz. Any questions from the commission?
Yes, Judge, I've got one. It's Commissioner Holzman.
Go ahead, Commissioner.
Thank you. Thank you for your testimony. In the past little bit here, we've had a policy discussion about time of use and access for net metered customers to have non-discriminatory access to the same rates as the rest of the rate base. How does Missouri stack up with other states when it comes to non-discriminatory access of renewable energy users? Can you speak to that?
Specific to the net metering customers, which has the 100 kW limit, I think we're about average for that net metering. Now that's set by Missouri statute. When it comes to independent power producers, such as qualified facilities, I would say that Missouri lags considerably. We can look at states that have moved forward with it, like North Carolina. South Carolina has done so, and we're seeing states in the industrial Midwest, like Michigan and Minnesota, move forward with more independent power producers. Just as an example, by way of potential investment that could happen, is there are significant industrial users, such as, be it, commercial poultry grow houses, or let's say hog CAFOs that use significant power. With updated standard offer contracts, right now they're limited to essentially 100 kW, or they've got to negotiate separate compensation with the utility. With a standard offer contract, it would really ease the ability of these power producers to put power on site to it could be behind the meter, it could be in front of the meter, to power their operations, because they're going to have more certainty in what compensation they'll get when the power they produce is put back onto the grid. Now, behind the meter, it could be sized to appropriately fit it, but when you're looking at a large facility, there may be times when they are down for operations or whatever it is, and they are putting that power back onto the grid. So having the ability to enter a standard offer contract would make it, in my view, a lot easier for some of these industrial customers to participate in renewable energy.
Don't we have some retail customers now in the state of Missouri that already have 1 megawatt behind the meter at their own, in an IKEA or something that has a 1 megawatt system that is generating power just for their use?
Yes, I believe that's true, and I think that their compensation was negotiated directly with Ameren, Missouri. Now, Ameren, their current tariffs, I believe, already permit up to 1 megawatt. And I think that was as a result of just their own initiative there. But I would say that their tariff sheets say you can elect to, up to that amount, you can elect to receive a certain compensation that changes every other year, I believe, or you can elect to not receive any compensation depending on how you hook your meter up. So if we were to say increase the standard offer contract to 5 megawatt, if there were a facility that could accommodate that amount of power, they would still have the opportunity to sell that excess onto the grid. Whereas right now, I don't think any of the current utilities have tariffs in place that would easily allow a non-sophisticated company to participate in that market.
What do you think would happen with the current customers who are in that situation where they already have taking advantage of that one? Are they going to be subject to the same new opportunities that are going to be presented? Will they be able to renegotiate their position with the company, or how do you envision that?
So for the net metering customers, that would remain, I guess, subject to the net metering rules, and it's basically going to be offset their retail rate plus the utilities avoided cost. For a customer,
No, I'm talking about the commercial customers.
for a commercial customer like an IKEA or
Yeah, exactly.
they're
If they already have a relationship with Ameren under the existing tariff, and this goes forward, will they be able to then go back and renegotiate their position, or are they grandfathered into the existing position? Do we know what happens with folks who are already producing this kind of power?
So I don't know the particular details of their individual contract. I think that they have a separate contract outside of the tariff. I'm not 100% sure on that, but I would envision that when the new tariffs go into place, the existing customers would be able to take advantage of those opportunities. And the reason I envision that is because I've seen case law, and it was sort of discussed in that new core case that says, yes, the utility and customers can enter contracts, but it's ultimately the commission that will establish the rates to be paid, and the commission isn't binding itself. So the commission can go ahead and update those contracts, as it were, if it sees fit, is my view.
What kind of forecast do you make if this goes forward with the type of, what percentage of the overall portfolio do you see being taken out these large generators, large customers?
Commissioner Holzman, could you repeat that question, please?
Yes. What kind of forecast do we see if this goes forward now? What kind of percentage of the overall portfolio will be taken advantage of by new businesses that maybe move to Missouri, or existing businesses here that would take advantage of an agreement or a tariff like this that would allow them to either generate their own power or have an agreement with someone who does for them? Like how much are we talking about here in terms of the usage of the new tariff?
I guess to the direct percentage, I don't know, Commissioner. I think that, again, that will be dependent on what this commission determines the avoided cost rates and the terms of the standard offer contracts that this rule would require the utilities to file, what that ultimately would be. I think that I'm aware of a few companies in Missouri who would take advantage of the solar at a large scale, and a few that are interested in something that might qualify under the cogeneration rules. Now, that's just an anecdotal handful of businesses that I'm aware of, but to put a specific percentage, I don't know, and I think it will be dependent on what the commission decides the avoided cost and contract length in those standard offer contracts will be.
Okay, thank you very much. Thank you, Judge. That's all I have.
Thank you, Commissioner. And just to clarify, Renew included an amended version of the proposed rule as attachment A to its written comments, correct?
That's correct, Judge, and our modifications are, because the Secretary of State uses bolding and italicized, I highlighted them in yellow, the language that we modified.
And I saw that. And so there was, the legally enforceable contract was a big yellow area for you guys. In other words, you proposed language in regard to that. And just to summarize, you indicated that you did not see, as some other parties have indicated they see, any sort of issue with avoided costs as put forth.
Can you repeat that? I thought you were going to ask about LEOs, but then you kind of asked about avoided costs.
Well, you're correct. So let's. I noticed that the LEO was the major change. That was one of the major changes that you proposed to the amended rule. I noticed you didn't really address avoided costs, and then during your oral comments, you seemed to indicate that you didn't have a problem with the way avoided costs is currently put. You said that the commission has experience handling or addressing avoided costs, and you even cited a section D4, I guess sort of a choose your own adventure avoided costs, for lack of a better word, for the utility. So you don't seem, but other parties have indicated or other commenters have indicated that they thought that avoided costs was not defined, that there failed to be a distinction between avoided costs and fuel costs.
Sure. So, first, I would say it's true that there isn't a number, that you can divine from this proposed rule, right? Just as there isn't a particular number with the current rules. But this proposed rule, and Renew Missouri was relatively satisfied with it. We didn't offer any changes to those calculations, provided options on how to evaluate what that avoided cost should be when the utilities make their filings. That included one that Renew Missouri has advocated for in the past, which is as developed from their IRP. Let me look at the rules here.
I guess without having to have you look at the rules, you felt that they were adequate the way they were in the proposed rule.
Yes, we felt that those were adequate ways to attempt to measure avoided cost. Our objectives here are to ensure that they're transparent, which I believe the rule talks about. They'll be submitted and available on the Commission's webpage whenever they're submitted. However, given that there are these options available, particularly that number 4, where the utility can sort of, as you say, choose your own adventure, I did insert a additional section E that talks about a time frame and sort of a process for choosing which of those will be included in the standard offer contract. That would then be, when it's included in the standard offer contract, that could then be the effective rate that the qualifying facility developer, once they establish their legally enforceable obligation, that they're able to move forward with. And so, I think Renew Missouri's preference would be that the avoided cost is based on the integrated resource plan development, because these projects, I think, are long-term. We propose 15 years for these rates, but I think that most projects will be around for 20 years or so. And we think that that's how the utilities do their own planning. So we think that's the appropriate way to look at avoided cost. Now, the electric utilities may have some different method, and so when they put forward their filing, they might say, well, we want to use the market prices in our RTO as our avoided cost. And so then we would want that opportunity in that section E to say, well, Commission, we appreciate that the company's perspective is that, but here is why you should go with their IRP based, which Commission you have experience looking at, within the context of the utilities integrated resources plans, and increasingly within the utilities MIA filings.
Okay, thank you.
Thank you.
Is that gentleman to your left to see what you...
Judge.
Yes, Commissioner.
Judge. I got one more question based on that response there.
Go right ahead, Commissioner.
Is that okay? Thank you. You mentioned a 15-year contract. Can you explain a little bit why you think it's necessary to have a 15-year contract in the proposal?
Yes, Commissioner. So I think it was in our proposed rules, I put them in the section 4 under the standard rates for purchase, talking about the contract tenure of 15 years. In prior dockets, we had proposed, I think, up to 20 years, 25 years, and there was significant pushback on that. So we decided, and we consulted with, people who are IPP developers that said, basically, if we can't have some certainty for 15 years, it's going to be nearly impossible for us to get the financing and to move forward with any of these projects. We think 15 years is shorter than what the utilities have to plan. Usually they're doing 20-year IRPs. The current rules I think as applied, every 2 years, the companies file their cogeneration and avoided cost rates. I think it's maybe it's January 15th. And so basically right now, if you are taking something under the avoided cost rates, it's only good for 2 years. And to develop a qualifying facility that has to basically pay for itself within 2 years, it's something that's just not feasible, at least in my knowledge and conversation with certain developers. But while we would appreciate, and I think a longer term would certainly go a long ways in encouraging more development, I think 15 years we settled on in this rule as something that is more palatable, hopefully, to this commission, and still gives some encouragement to our qualifying facility developers.
Okay, thank you. And Judge, I would like to have that question posed to the utilities as well.
Okay, Ms. Johnson?
When it's appropriate.
I think now would be the appropriate time since the utilities have already gone back. So if you would, Ms. Johnson, can you answer that question? Are you still on the WebEx?
I am still here, yes, Your Honor. Could you restate the question for me, please?
I believe it was as to the length of the 15-year contract and why 15-year contract was appropriate or inappropriate. And I believe Mr. Opitz said that that was the amount of planning time needed, and additionally it was still less than the amount of time that utilities plan for, given that their IRP is usually done on a 20-year planning period. Did I correctly state your question,
Thank you.
Commissioner Goldsman?
Yes, you did.
Okay, go ahead and answer, Ms. Johnson.
Great. Certainly, thank you. I appreciate you restating it. I wanted to make sure I got the gist of the question correctly. I think, yeah, we do a 20-year planning horizon when we're developing our IRP, but I think it's also important to remember that we redo our IRP every 3 years. So I think we still need to retain flexibility when we're looking at some of these developments. There very well are a lot of different case-by-case things that could impact the length of the viability. I mean, depending on the equipment used, the type of cogen, whether it's wind, whether it's solar panels.
Ms. Johnson, can you back up just a second? You cut out during that last sentence, so if you could back up one sentence, please.
Oh, certainly. I just think it's important to think about all the things that on a case-by-case basis, because depending on the technology, whether it's wind or a solar panel or a cogeneration facility, depending on where it's located, there are a lot of factors that we really need to maintain the flexibility to look at those factors on the whole and figure out how they figure into the planning. Because again, yes, we look at a certain planning horizon, but we also re-up that every 3 years, because we're not just looking at economics, we're looking at what's actually needed. And there is a very good chance that at some point, there may not be the need, in which case we may need to go back and renegotiate some of these contracts, which may be somewhat difficult if we're locked into a 15-year plus term. So I really think we need to maintain that flexibility so we can continue adjusting as needed as we go through these processes in our planning processes.
Okay, as a follow-up to that, do you agree that not having at least the certainty of 15 years will discourage or make it more difficult to get financing or get the projects in place if a bank won't secure the note for that period of time? Will that make it more difficult to do these projects if they don't have a 15-year guarantee?
That's really a question that the developer and the bank have to work through together. I don't know that I could necessarily speak to that directly, but I do know I can speak to wanting to make sure that when we're doing our planning, that we're doing it for the greatest benefit for our customers, because at the end of the day, they're the ones who pay those energy costs. And if we're paying for energy costs that as we get along with our planning, we determined we didn't need, are we really doing a disservice to our customers?
So it's fair to say that you oppose the 15-year requirement.
I think in certain cases it may be appropriate, but I oppose locking it in because we really need to be able to look at these developments on a case-by-case basis.
Okay, thank you, Judge. I don't know if Evergy has any position on it or not, but that's satisfactory for me from Ameren.
Thank you. Mr. Fisher, do you have anything to add on behalf of Evergy?
I don't think I have too much to add from what Paula Johnson said. I would note that, just in my experience, the IRP process, we do change that quite a bit every 3 years. You see, quite a change over a period of time, and I think that's important to take into account. I'd want my subject matter experts to weigh in on some of those technical questions about financing, though.
Okay, thank you, Mr. Fisher. Commissioner Holzman, do you have any other questions at this time?
Not at this time. Nope. Thank you.
Okay. Mr. Opitz, it looks like you wanted to address some of those?
Yes, Judge. I want to go back to before we deferred to the other utilities. You started to ask who was sitting next to me. I just want to say this is Renew Missouri's Executive Director, James Owen. I don't know if he has any comments or I don't know what your question was to do that, but I wanted to circle back to that.
If we're trying to socially distance as much as possible, I noticed that this gentleman walked in late. If he wasn't with you, I wanted to be sure that maybe we put him at a different table. That was my only concern there.
Okay,
But if you're
thank you, Judge.
comfortable with him being there with you, that's fine for me.
We've been sharing office space of recent, so I think we're both okay. We'll do whatever is comfortable with the court.
So, thank you, Judge. And then I guess I would note that although the IRP process does change every 3 years, once that plant is in the ground, the utility recovers that. They don't change the plant every 3 years. So that's all I have to say.
Thank you, Mr. Opitz. Okay, are there any, I know I asked once already, but just in case they've joined us, is there anybody from Midwest Cogeneration Association, Missouri Solar Energy Industries Association, or the Empire District Electric Company that has joined the hearing? Okay, I hear no one. With that in mind, I will move on to the Office of the Public Counsel. Did you have any additional oral comments you wanted to offer to the Commission today, Mr. Hall?
Yes, Your Honor, briefly. As can be made apparent by our filing, we're not taking any substantive position in this rulemaking docket. We offered comments purely from a drafting and technical standpoint. We asked the Commission to take note of consistent citations within its rules once it's proposing them. We want to reiterate a consistent application of the term avoided cost versus the term avoided fuel costs. There's the net metering statute that separately defines avoided fuel costs. That term is used as separate and apart from avoided costs, and we want the Commission to consider and deliberate on when it wants to use that term versus another, because when you look at these two rules, it seems like the use of avoided fuel costs versus avoided costs seems to denote that there's a difference between the two, and to avoid future fights and disagreements as to that term, the Commission should take note of using terms exactly for what they mean and what it wants them to do. I guess finally, there's been our office received comments from staff in response to the comments the OPC made regarding the definition section. The Commission is proposing to refer generally back to definitions within PURPA for many of the terms that are proposed to be deleted here. I'm open to be proven wrong. The concern that I have is I'm being told that avoided costs not avoided costs, but qualifying facility in other terms are defined within PURPA. But when I go back to PURPA, I'm not finding those terms. I can't find that phrase qualifying facility defined in 92 statute section 3117, which was the original enactment of PURPA. I'm not finding it within 16 U.S. Code section 2602 or in 16 U.S.C. 824. So perhaps this type of confusion could be alleviated by citing specifically to the federal code that the commission is relying upon for future definitions. And those are all my comments. Thank you.
Thank you, Mr. Hall. Any questions from the commission? I hear none. I have no questions. I had an opportunity to look over the written comments. And finally, the commission staff. Do you have any comments that you wanted to offer?
Yes, thank you, Judge. Good morning.
Now I'm sorry to interrupt, you had actually sent around electronically to the parties today a attachment to your comments here today.
Yes, I emailed to all counsel and all parties a copy of our written comments. We don't intend to enter those into evidence, but we're providing that to facilitate the commission and the court reporter. This is getting pretty detailed and to help people understand what our position is on this. So we're not offering this as evidence. We're simply offering it as a handout.
Okay, and I wasn't trying to prevent you from doing so. If it said evidence in the first paragraph, I believe.
We would only offer it as demonstrative evidence.
Oh, exhibit, it says in the first paragraph. Okay, well then go ahead and you're welcome to reference it. If you decide that you want to file it as an exhibit in this case, let me know.
We will, thank you. As to the issue of whether this rulemaking procedure should proceed,
Can you pull your mic down?
Oh, yes. Thank you. As to the issue of whether this rulemaking docket should proceed, we would direct the commission to our July 29th filing. There has been significant stakeholder input to this point, and putting off the process with the Missouri rules while we wait for a final rule from FERC would actually derail the process and is also inconsistent with the Executive Order 17-03, which states that federal agencies should streamline their regulations. As to the rules substantively, we were asked Claire Eubanks to offer some comments, which it will be similar to what was sent to the parties last night and this morning.
Okay, thank you. Go ahead, Ms. Eubanks.
Good morning. My name is Claire Eubanks, and I am the manager of the Engineering Analysis Department. I would like to respond to some of the comments that stakeholders filed. Staff Counsel has provided a copy of my comments to assist the Commission. Staff and stakeholders have considered amendments to the cogeneration and net metering rules over 4 recent dockets, including EW-2018-0078, where staff additionally reviewed the existing rules in compliance with Executive Order 17-03. As a result of that review, staff recommends the cogeneration filing requirements be moved to Chapter 20, Electric Utilities. Therefore, with this rulemaking, staff is proposing to rescind 20 CSR 4240-3.115 requirements for electric utility cogeneration tariff filings, and incorporate the filing requirements into 20 CSR 4240-20.060 cogeneration and small power production. Additionally, staff is proposing an amendment to 20 CSR 4240-20.065 net metering. This change is designed to simplify the existing commission rules by combining most electric-only rules into the electric utility chapter. As indicated in staff's comments filed on July 29, 2020, staff supports the rescission as proposed. Staff will address the individual provisions of the amendment to the cogeneration and small power production and net metering rules based on the stakeholder comments filed. The proposed revisions to the cogeneration and small power production rule include several instances of renumbering. For clarity, staff will reference the proposed rule location as published by the Secretary of State on July 1st, 2020. I will also note that the published rule corrected many of the renumbering issues identified by OPC and the utilities. First, starting with the prepared responsive comments to the cogeneration and small power production rule, starting with definitions. Stakeholders suggested several changes to either add or remove definitions from what was published by the Secretary of State on July 1st, 2020. The utilities in the Office of Public Counsel commented on the definition of voided costs contained in 20 CSR 4240-20.060 1A, because the language in 20 CSR 4240-20.0601 indicates definitions shall have the same meaning as PURPA unless otherwise defined. The utilities recommended the voided cost definition be removed. As originally proposed in the notice of proposed rulemaking, there were no changes to 20 CSR 4240-20.060 1A, and this subsection was not published in the Missouri Register. There's additional notations in the footnote in the handout. Staff is not opposed to the definition being removed from the rule. A little later, staff will respond to OPC's concerns regarding the definition of voided costs as it pertains to the net metering rule. Renew suggested adding two definitions, time of delivery rates and time of obligation rates. These phrases are not used in 20 CSR 4240-20.060 5C or in Renew's proposed additions. Finally, the Commission proposes to remove the definition for qualifying facility from the rule, but also continues to use that phrase for new operative language. Given the repeated use of qualifying facility within 20 CSR 4240-20.060 and the threshold question of applicability when deciding whether these rules apply to a cogeneration facility, OPC recommended that the Commission not remove the definition of qualifying facility from 20 CSR 4240-20.060. As previously stated, because the language in 20 CSR 4240-20.0601 indicates definition shall have the same meaning as PURPA unless otherwise defined, and because the qualifying facility is defined by PURPA and it's implementing federal regulations, it is not necessary to define the qualifying facility in the Commission's rule. As OPC noted today, they had trouble finding that specific definition. We will have to find the reference specific. I didn't write that down for today's comments. So now I will address specific comments on specific rule sections, starting with 20 CSR 4240-20.060, Section 4, Standard Rates for Purchase and Standard Contracts. Specifically, starting with paragraph A. Staff recommends changing 20 CSR 4240-20.060 for A1 to read of 100 parentheses 100 close parentheses kilowatts or less, and regarding Renew's suggestion to add several tiers of standard contracts up to 20 megawatts, staff offers that the 1,000 kilowatt limit was chosen based on weighing the comments of the utilities and other stakeholders during the working docket. Most persuasive to a lower threshold was Empire's comment on evaluating its distribution system at various levels, and that even at 1,000 kilowatts, there were deficiencies in some areas of its system. Further, the standard contract would not limit the ability of larger systems to interconnect and receive rates for purchase. The cogeneration or small power production facility owner would in those cases negotiate a contract with the utility rather than being offered a standard contract. If the Commission is interested in increasing the standard contract size, staff recommends the range in 20 CSR 4240-20.060 4A2 be changed rather than adding additional tiers. Staff also recommends the utilities comment on whether there is a fiscal impact that has not already been considered with the additional tiers. Moving on to 20 CSR 4240-20.060 4C. Staff recommends changing the first sentence of 20 CSR 4240-20.0604C to read, "The utility shall apply and the commission shall approve standard contract templates for purchases from qualifying facilities with the design capacities described in 4A within 9 months of the effective date of this rule." Next, in 20 CSR 4240-20.0604D, staff recommends adding a sentence to 20 CSR 4240-20.0604D stating, "Technical and performance standards shall include reference to applicable standards, including the year published." Moving on to 20 CSR 4240-20.060, Section 5, Rates for Purchase. 20 CSR 4240-20.0605D1. Staff recommends changing this rule reference to read, the data provided pursuant to Section 11 of this rule, including commission review of any such data." Moving on to 20 CSR 4240-20.06011, filing requirements. I have 2 comments on this section. 20 CSR 4240-20.06011C2. As discussed previously, Renew suggests adding several tiers of standard contracts above 1,000 kilowatts in 20 CSR 4240-20.060.4. If the commission revises section 4 to include a value higher than 1,000 kilowatts, staff recommends 20 CSR 4240-20.06011C2 be modified to include the higher value rather than adding the additional paragraphs as recommended by Renew. 20 CSR 4240-20.06011D, staff recommends this portion be modified to read, "In establishing the avoided cost on the electric utility system in accordance with paragraph 11B1, the following methodologies may be utilized." Other comments related to this section, Renew Missouri suggests adding language to section 11 regarding opening a contested case. Staff believes this language is unnecessary and would point the commission to section 11A, which states the required filings will be made in accordance with 20 CSR 4240-2.0654, which is the commission's rule for tariff filings, which create cases. The filing of the tariff will establish a case file for the commission to specifically approve the tariff. Renew Missouri suggests adding a section 13 related to legally enforceable obligations. Staff notes that legally enforceable obligations are also discussed in 20 CSR 4240 20.0605C. Would you like to ask questions regarding cogeneration now, or shall I move on to our prepared comments on net metering?
Are there any commission questions regarding cogeneration? I hear none, Ms. Eubanks. If you would like to continue on into net metering.
Okay. Here are prepared responsive comments regarding net metering, starting with the definitions. OPC questioned the clarity of the net metering definition of voided fuel costs, referring back generally to the cogeneration and small power production rule. Purple allows for the calculated avoided costs to include capacity and/or energy. However, the net metering statute, chapter 386.890 RSMO, defines avoided fuel cost as the current average cost of fuel for the entity generating electricity as defined by, in this instance, the commission. The existing definition points to the rate established per the cogeneration rule, such that net metering customers would receive the same rate as cogeneration customers. Staff proposes 20 CSR 4240-20.0651B be modified to read, "Avoided fuel cost means the incremental cost to the electric utility of electric energy, but for the purchase from the customer generator, the utility would generate itself or purchase from another source. Avoided fuel cost is used to calculate the electric utility standard rate for purchase from systems less than 100 parentheses 100, close parentheses, kilowatts pursuant to 20 CSR 4240-20.060. The information used to calculate this rate is provided to the Commission biannually and maintained for public inspection. Moving on to 20 CSR 4240-20.065, Section 5, Qualified Electric Customer Generator Obligations. 20 CSR 4240-20.065, 5A. The utilities recommended removing the version identification from the reference standards for ease of updating the rule in the future, but offer the change would be appropriate in technical and performance standards developed per proposed rule 20 CSR 4240-20.0604D. Staff had proposed to identify the version of the standard because otherwise the rule implies the most recent version is applicable. Further, foundational steps have not yet been made to adopt the most recent IEEE 1547 revision. Specifically, the revised standard includes a new definition, the authority governing interconnection requirements, and suggests a stakeholder process to consider policy implications of adopting the new standard. It is staff's opinion that the Commission is the authority governing interconnection requirements, though the Commission may choose to delegate that authority to the utility. Although staff was interested and continues to be interested in pursuing the adoption of the revised standards, the utility stakeholders were not prepared to do so in the working docket for this rulemaking. Because the proposed amendments to the cogeneration rule contemplate Commission approval of the technical specifications, staff recommends the version reference be removed as recommended by the utilities, provided that the Commission adopts staff's proposed language here today, presented earlier in 20 CSR 4240-20.0604D and forthcoming in 20 CSR 4240-20.0657A, which is where I'm moving next on the interconnection application. 20 CSR 4240-20.0657A. As discussed previously, if the standard version references are removed from the final rule, staff recommends 20 CSR 4240-20.0657A be modified to read as follows. Each customer generator and electric utility shall enter into an interconnection agreement which includes technical and performance standards and interconnection testing requirements developed per 20 CSR 4240-20.064, excuse me, I read that wrong, 20 CSR 4240-20.0604D. The interconnection agreement will be substantially the same as the interconnection application located on the Commission's website and incorporated by reference. The utilities expressed concerns with removing the form from the rule and placing it on the Commission website, specifically related to existing Ameren variances. Staff sees this modification as a simplification, which would not require variances for minor wording changes. Further, removing forms from the rule would be in compliance with Executive Order 17-03. 20 CSR 4240-20.0658C. Staff recommends 20 CSR 4240-20.0658C be amended to read, verify compliance with 20 CSR 4240-20.06011C for customer generator systems and finally, 20 CSR 4240-20.0658D. Staff recommends 20 CSR 4240-20.0658D be renumbered to be 20 CSR 4240-20.0659. Finally, as staff noted in its July 29th comments, the Federal Energy Regulatory Commission is in the process of amending its PURPA rules. At the appropriate time, staff plans to file another working docket to further address any amendments to the Commission's rules. Any comments that are not addressed in this rulemaking may be further addressed in that future rulemaking. Thank you, and I'm happy to answer any questions.
Any questions from the Commission? Hearing none, it looks like, at least in regard to these last couple, those just kind of codify suggestions that I've seen in other comments from other parties. Is that correct?
Yes, proposed language in response to other parties' comments.
Thank you very much.
You're welcome.
Are there any other comments at this time?
Your Honor, Natal Dietrich, Director Industry Analysis Division. Just to clarify the record, there have been several references to Executive Order 1703, and I believe in one of the discussions it was mentioned that that was a federal executive order. I just wanted to clarify that that's a state federal order Governor Greitens issued.
Thank you for clarifying that. I did hear the word federal, but I knew what we were talking about. Thank you. And that has to do with the simplification of the rules statewide.
Correct.
Are there any other comments this time? Are there any other issues or matters that need to be addressed by the commission during this rulemaking hearing? Okay, I see none. With that in mind, this hearing is adjourned and we will go off the record.